Detroit versus Javar Grayson, case number SP 1463900, counts 1, 2, and 3, SP 146409991, SP 146436761. Appearance for the record, please.
Grayson Bay.
Sherika Harris on behalf of Mr. Grayson Bay.
All right. Good morning to you, sir.
Your Honor, I'm going to represent myself in this matter. And for the record, my name is Grayson Bay.
All right. City of Detroit versus Javar Grayson Bay. Your offer, sir, is a $240 fine, failure to display, and a seatbelt ticket. You pay those, we'll close the other matters out. That will abstract to the Secretary of State. And then the seatbelt ticket is $65. So $240, $65. We'll close the matters. We'll close the matters out. That'll be a failure to display. It will abstract, but it won't carry any points. And today is the date and time set for a trial.
Your Honor, today was supposed to be set for trial, and I don't consent to any of this.
Okay, it is set for trial. I just gave you your offer so that you can you go in? Okay, there. I just gave you your offer so you could.
I'm not accepting that. I won't accept that offer.
Mr. Corporal Ambrose, can you put your appearance on the record, please?
Good morning, Corporal Brian Ambrose. Detroit Police Department, Badge 415.
Good morning to you. Okay, let's go. Are you ready to proceed, Corporal Ambrose?
Yeah.
Your Honor, I would object to holding this trial. I believe he stated that he's a different person. We have a ticket for a Mr. Javar Grayson. Grayson Bay is an entirely different person. We don't have jurisdiction over. We don't have a case over. I would object to holding that trial.
I'm going to deny the objection. He just said he's Grayson Bay. He just I don't think he's objecting to the fact.
I object to that, Your Honor. I'm objecting, and I also questioning jurisdiction.
Buckle up, guys. Today we're going to watch a routine traffic case morph into a sovereignty showdown. The judge floats a clean off-ramp. $240 for failure to display, plus $65 for a seat belt, no points, and the rest closes. The defendant declares pro se, rejects the deal, and claims prosecution needs his consent. The bench corrects the myth, confirms the trial setting, and plants a flag. Court rules, not personal doctrine, control what happens next.
Well, I'm denying your motion about jurisdiction, sir. The court has jurisdiction over you, so are you ready to proceed, Mr. Grayson Bay?
No, I'm not. I object to anything that you call yourself doing. Also, I'd like to add that I sent this Brian and brochure. I sent him a COL. It's a cut-off law form. I warned him about this situation. This process is also in Wayne County. He's being sued. We can continue this all day. I also will add you to the case if you want to continue this. This needs to be dismissed today. I will see Brian Ambrosius in 3 weeks in Wayne County.
All right. Well, let's go ahead and proceed because it's not going to be dismissed today. Okay.
Well,
so you can do what you want to do over in circuit court. Then have your way. That is your right. I don't know how you're proceeding in circuit court when you feel that this court doesn't even have jurisdiction over you. So let's go ahead and proceed. Corporal Ambrose, you want to speak with them before we proceed, Ms. Snyder?
Yes, Your Honor, and I do think we just need to clear up on the record that Your Honor has denied my motion to not have this matter heard today based on this defendant saying he is not the defendant before us. And also that defendant has agreed that he is not the defendant before us, but Your Honor is telling us to still do this trial. I need to make sure that's clear on the record.
Yeah, I don't think that he's denying that he's not Javar Grayson Bay. Are you denying that you're not you're Javar Grayson Bay, sir?
I am the living person, Grayson Bay.
Okay,
Javar
so there
Grayson
it
is an
is.
artificial.
However he wants to articulate it, we'll let him articulate that. He's Grayson Bay. He's Javar Grayson Bay. His mom gave him that name. I don't think that's any dispute. Okay, so
That name has a social security card attached to it. It also has
I think it's going to be pretty quick, Ms. Snyder. I'll put you in a breakout room with Corporal Ambrose and put it that way. It is just a.
The defense tries to derail on jurisdiction and identity, hinting that Grayson Bay isn't a ticketed person. The judge separates noise from law. The court has personal jurisdiction when the defendant appears, and venue if the offense is in Wayne County. Mere objection without substance won't halt the train. Prosecutor presses for clarity, but the court signals readiness to proceed under ordinary procedure.
An expired plate, a seatbelt ticket, no proof of insurance. What is this other thing? Refuse to exhibit license and a false information ID. So just join the breakout room, have a conversation with Corporal Ambrose, and then we'll just hear it. And if he has a right to remain silent, he says he doesn't want to be represented by a lawyer, and you can just put your case on the record, and I'll have to make a decision based on that. An interlocutory appeal on my motion, on your motion.
Yes, Your Honor.
Okay.
Or I suppose time to brief the issue, maybe on this record, or I'd leave in Your Honor's discretion.
Let's see does that interlocutory appeal, if that is
I'm sorry, Your Honor. Are we back on the record for Grayson?
Yeah, let's go back on the record with Mr. Javar Grayson Bay. Now, there's that interlocutory appeal. I mean, I have to proceed. I mean, I got the discretion of whether I want to allow you to do that or not, or just proceed, and you can file your appeal. Correct? Give me the law on that. You're muted, Miss. You're muted, Miss Snyder.
I'm sorry, Your Honor. My supervisor's talking to me over the wall, so it's hard to hear two people at once.
Okay.
Identity turns tactical. The prosecutor wants the record airtight. The judge views it as straightforward. Same person, different styling. A breakout with the officer is teed up to streamline testimony. The court frames the case as basic traffic violations against a defendant leaning on pseudo-legal jargon. Stakes are modest, but precedent and record cleanliness matter. So everyone jockeys for procedural advantage.
The court rule is, I think she might be coming back. It's MCR 7.205.
205, application for leave to appeal, and you said, what was the citation? What were the other?
7.212, but that's just saying the format for briefs.
I have 7.205 as application for leave to appeal. Appeals to circuit court. 7.105. If the order appealed is interlocutory, setting forth facts showing how the appellant would suffer substantial harm by awaiting final judgment before taking an appeal.
We believe that the substantial harm that the people would suffer would be the defendant has already stated he's filing numerous lawsuits against the court, against the parties, against the officer. We believe we'd be giving him a golden parachute. It's just one more issue to add to his level of appeals. This is one issue that needs to be clarified. Of course, he will be found, I believe, through fingerprints to be either the person given that ticket or Javar Grayson, the person given the ticket, will be given a capias warrant and we can move on. But I do believe that this issue needs to be handled before we make a further record, I have a duty to mitigate the city's damages. And I believe that's what we're doing and what I was advised to do by my supervisor.
But how would the city be harmed at all if we proceed? What would be any harm for the city? Especially if you acknowledge the fact that you think that by fingerprints that would be Mr. Javar Grayson.
But Your Honor, what we think and what we can prove as a matter of the record and as the court of law is different. I do understand. I believe he's being frivolous. I think he is wasting the court's time. But I do think that as lawyers, as a court of law who do have to face appellate issues, this is something that we need to clear up on the record and have a clear record, such as a chain of custody of who Mr. Grayson is. I don't think it would take that long. Or we could solve this today with giving Javar Grayson a capious warrant and let Bay, whoever he may be, go on about his business. Either or. But I do think that having this trial over both of our objections is not the correct answer.
I just don't feel. I just don't feel.
You can't stand
one. I don't see any harm in proceeding. He's already indicated that he is Javar Grayson, except he wants to be acknowledged as Javar Grayson Bay, or he's the living. I don't know how he termed it. Person of Javar Grayson Bay. I don't think that, as a matter of fact, when Corporal Ambrose came in the room and introduced himself, I saw Mr.
The prosecution pivots to an interlocutory appeal, citing Michigan court rules on leave to appeal and briefing, arguing substantial harm if the identity issue isn't resolved now. They fear a frivolous litigation boomerang later. The judge isn't convinced there's any real prejudice in proceeding today and asks for concrete authority. It's efficiency versus insulation from appellate headaches, with the clock ticking.
Grayson Bay sort of kind of had a look on his face, and to me, I took that look as he knows Corporal Ambrose, and it's no question. I haven't asked Corporal Ambrose if this is the person that he pulled over, but I'll definitely let you ask Corporal Ambrose that. But I don't think that there is any sort of identity issue here. I think the issue comes into something that we've seen probably, I don't know how many times, and I'm sure we're going to see it more in the future. And I agree that those things are frivolous and they do not apply. So I don't see anywhere where we can't proceed. Corporal Ambrose says that to you and through you that this is not, I don't recognize this person that's here. And was this not the person that, or even if there was, I would even allow Mr. Grayson Bay to put on a identity defense and say, that wasn't me. He didn't. That wasn't the defense. I don't know what his defense is going to be.
Your Honor, may I?
No, you can't. No, you can't. No. When I ask you to, when I want you to speak,
no
I'll allow you to speak. I'm going to give you that opportunity.
No problem.
So to settle this matter about your objection, it's like if the court rules bound me not to proceed because you wanted an interlocutory appeal, then that would be the court rules would bind me to do so. But I don't know of a court rule that's going to bind me not to appeal. And I just don't see in what harm it will be to any other parties, the defense or the city, by us proceeding in this fashion. I understand he's got cases over in circuit court. He may have cases over in federal court. I don't know. But here again, we're here. The parties are present, and I'm satisfied at least that that's the Mr. Javar Grayson Bay, that we have the right person here in court today. So I'll let you make a last minute record, Ms. Schneider.
Can I just have one? My supervisor walked away. Can I have 1 second to go talk to her?
Yes. Now, you can, well, let's see if you want to, if Mr. Grayson has anything, I'm gonna allow him an opportunity to speak so you can hear what he has to say. Go ahead, Mr. Grayson Bay.
Practicality wins ground. The judge notes the defendant's apparent recognition of the officer and invites an identity defense if that's truly the claim. The court underscores a familiar pattern. Sovereign rhetoric rarely meets evidentiary standards. Unless the officer says this isn't the driver, the bench sees no barrier to trial. The message is clear. Facts and testimony, not labels, will decide this.
Your Honor, I sent you a declaration of notice stating who I am and the fraud, Gerard Grayson. I sent you the paperwork. This was over 3 or 4 months ago. I'm pretty sure you have plenty of time to read and understand the situation. And that, like I said, again, that is my declaration of notice. You should have that in the file as we speak.
Anything further?
And I object to this. And again, your court system has no jurisdiction over it.
What is your, give me a point to a court rule or put your legal objection on the record. What is your objection?
My objection is jurisdiction.
Okay, I deny that objection. All right, go ahead, Ms. Snyder, we'll pass the matter. We'll allow you to speak with your supervisor. All right, let's go back on the record with Mr. Grayson Bay. Are you there, Mr. Grayson Bay?
Yes, I am.
What I will do, listen, Ms. Snyder, let's go back on the record with Ms. Grayson. What I will do is I will pass this matter and I will reset this trial date for an in-person, because I think this is one that needs to be in person. We can't, it's been some stuff that Mr. Grayson Bay has said that he has filed with this court. He says he sent me some stuff. I don't have that in front of me. There's it in the file. And this one seems like it's going to necessitate some, it's going to necessitate a trial and I think that this one is best to be done in person. So what I will do is I will reset this trial date. That will give me an opportunity, one, to get the documents that, if they exist, that Mr. Grayson Bay has said that he has filed with this court. And then two, that will have both of the parties here in person. All right, so I'm going to reset this matter for a January 9th in-person trial date.
The defendant touts a declaration of notice and floods of pseudo-legal filings. The judge checks the file, finds nothing useful, and refuses to elevate paperwork theater over admissible proof. Jurisdiction is challenged yet again and denied yet again. With patience thinning, the court pauses proceedings briefly, signaling that argument without authority won't change the legal footing already established.
Now let me ask you this, sir. You understand you have a right to a trial by jury, correct? Mr. Grayson Bay?
I'm just challenging jurisdiction. Also, for the record, I sent Detroit Police Department 12th Precinct a declaration of notice. I also sent them a COL, which is a color of law.
Listen, Mr. Grayson Bay. Listen, Mr. Grayson Bay. I don't care about that stuff. All I care about is what's here before me right now.
Okay. Did you get the declaration of notice?
I don't. If I did, it's not in the file. I'm not going to say I didn't.
Okay, I'll send you another copy.
Let's make this a jury trial too.
I send you a copy. No, it's not a jury trial.
No,
You
it
have
is a
the
judge.
situation in your hands. No jury
gonna
trial.
be a
You have the
jury
situation in
trial.
your hands. Make a decision today, young. Make a decision.
I don't know why you made it.
Can I have a breakout room with Mr. Grayson?
No, it's not gonna be a breakout room with him. Let's get him a jury trial date.
Oh, jury trial.
Yes. Let's just go ahead and he's not running this show.
I have Judge Carpenter hold.
Okay.
Do you have somebody like you want to assign to this case?
Not necessarily. I mean, anybody can, I'm sure, handle it.
Okay, that's fine. Thank you, Judge.
Yeah, let's get it.
If Miss, I'm not talking to you, let's go off the record. Miss Harris, do you want the case of Gomez Lopez?
No, thank you, Your Honor.
Okay.
I can't hear them all.
Everybody here.
No, it's not. We're not talking about your case. We're off the record with your case. We get a jury trial date. Let a jury of his peers make the determination.
And I think we'll clean up the record issue with him in person.
Judge, let me know when you're ready for the date.
All right, let's get a jury trial date. Tuesday, December the 5th, jury trial.
Come get it.
We'll not schedule anything else on that day.
Okay.
Tuesday, December the 5th, 9 a.m. we will do. As far as motions are concerned, I'm going to set some motion dates.
Cover his ass.
So, what was that comment, sir? Mr. Grayson Bay?
Yes, sir. What's going on?
Was that comment?
No comment. Listening. Let's go.
Reset time. The judge moves the case to an in-person setting to gather any missing documents and eliminate Zoom fog. The defendant resists a jury. The judge orders one anyway, asserting control of the docket and a cleaner record path. It's a procedural reset that protects due process while boxing in the theatrics. Next round will be live, with testimony, deadlines, and fewer distractions.
All right. Let's set a motion date for November the 10th. That's when Mr. Grayson.
That's Veterans Day, sir.
By your ear.
Okay, good. Let's set motion the motion will be due by motions due by November the 9th. That's for both parties. The responses to the motions will be by November the 17th, and we will set a final pretrial date a day before on December the 4th, 2023. So technically, you'll have a court date that can be on Zoom for the final pretrial date of December 4th. If there hasn't any resolution, I'll get my ruling on the motions on that day. And then we'll set the jury trial date for December the 5th, 2023 at 9 a.m. All right? You got that, Mr. Grayson Bay?
No, you gave me 10 dates, but what I'm going to do is I'm going to send you a declaration of notice.
I did not give you 10 dates.
I count, let's see, 1, 2, 3. I got December the 5th, December the 4th. I got November the 9th. I got also November the 17th for a response. That's 1, 2. That's like what, 5?
Dates lock in, motions due, responses set. Final pretrial on the eve of a jury trial. The defendant quibbles over counting. The judge calmly recaps and keeps the schedule intact. It ends with a tidy roadmap, trial by facts, not folklore. If you enjoyed this breakdown, don't forget to like the video and subscribe to the channel, and we'll see you in the next video.